Hello, everyone. Hello, ma'am. Very good evening. Good evening to all of you. Welcome to today's IDCSS session. And it's my pleasure to introduce today's speaker, Advocate Puneet Basin. I hope, ma'am, you are able to unmute yourself and you can. I gave you the permission. Yes.
Yes, Deepali, good evening.
Yes, ma'am. So we are having Advocate Puneet Basin, internationally recognized cyber lawyer and privacy data protection EU GDPR expert. So we are honored to have her share his insights with us today. And at the end, we will be having 15-minute Q&A session. So over to you, ma'am. Let me share my screen.
Yes.
I hope it is visible now, ma'am.
Yes. Good evening to everyone here. I'm sure many of you have heard about multiple aspects of cyber laws now. Initially, there were aspects like more pertaining to domestic cyber crimes. People were talking about unauthorized access. And over the last couple of years, cyber warfare has taken the forefront. In the outset, when all these things happening globally and cyber warfare coming to the forefront, international cyber law is what gains extreme importance to ensure that nations are aligned with each other. Deepali, is this session being recorded?
Yes, ma'am. This session is recorded.
Okay. Do share the recording with me also. The
Yes,
next
ma'am.
slide.
Sure.
The next slide, please. This is a brief introduction about myself. I'm a practitioner in the space of cyber law, cybersecurity, and data protection compliance in India. Um, Obviously, clients spanning over 500 different organizations all over the globe to whom we have serviced in this space. My firm is CyberCheer Legal Consulting, and it's been over 15 years working in this space and ensuring the growth of India and legislative reforms in our country to combat with the latest developments globally happening in cyber laws and cyber crimes. The next slide, please. The next slide, please. This is also an introduction about me. For those who wish to connect, you can reach out to me on LinkedIn or the lectures of mine on YouTube, the next channel. The next slide, please. You can follow me on YouTube to hear more lectures on data protection and cyber laws. Today will only be a brief overview of international cyber laws. The next slide, please. Some of my books which you can read in detail on this subject. Let's start with the need and the reason why we are having this subject and discussion. In today's day and age, I think everybody would admit that everything is digital, from your payments to your relationships. Nothing in this planet is not touched by digitization. In such a scenario, only having laws governing physical aspects of life do not suffice. So a lot of countries have gone ahead and implemented legislations to regulate cyberspace. However, there is a lot that still needs to be done there, especially because a lot of domestic laws pertaining to this, despite having extraterritorial jurisdiction, the implementation of that extraterritorial jurisdiction is a challenge when it involves other countries. The issues of sovereignty of each country coming into the picture, the challenges posed by big tech organizations claiming to be regulated and governed by the laws of other countries, not your own law of the country where they're providing the services. Like many of you would have read about it in the newspapers also, that when the Digital Data Protection Act in India came in, and also the social media regulations, a lot of tech giants had gone ahead and filed cases in the High Court that this cannot be implemented, it is illegal, that they should not be brought within the purview of Indian law. As a matter of fact, there was a huge case of Twitter in the case of the social media regulations of 2021. The moment those rules came out, Twitter had gone to the High Court. and stated that they should be considered out of the purview of the same, and they should not be mandated to have set up an office in India, be regulated by the Indian laws. And the Indian courts took a very strong stand that if you're providing services in India, in Indian cyberspace to Indians, by default, you are governed by Indian law. So it is a settled principle of law now. But yes, despite being a settled principle of law, there is a lot of resistance that is there from a lot of big tech giants who obviously want data and want all of the control of their applications to be governed by parent organizations or parent country laws. Now, why does this happen? Especially if I have to tell you from an India perspective, India is I would say in a way a data nation, as what I always say. No other nation generates as much diverse demographic data what India does. So majority, if you will see, of any social media app or any service provider who's providing digital services online, if India is removed from the demographic of their viewership or their clientele, a major chunk is actually gone. They have a very less business, a business that cannot even sustain their organizations to a great extent. So a lot of applications that you see that are offering you free services. So for example, social media applications, it's not actually what is free. It is your data that is being harvested. And if India is out of the picture, Indian data is out of the picture, then practically there is nothing left on those applications. To just explain to you why we require international regulation, I am sure when all of you joined social media, that would be when the times of Orkut was there. How many of you were there on Orkut at some point of time? By a raising of hands in this session itself, you can just raise your hand out there. A majority of you all would have been on Orkut. Now, after Orkut came Facebook, then came Instagram, and multiple other applications which are into social media and networking. Now, what was the whole concept with which social media started? It was meant to virtually connect you with the people whom you know. So basically, when it started with Orkut, when it started with Facebook, your own campus people of the college, other campus people. So basically, knowing and connecting virtually with people you know. Then over the years, it evolved to knowing and connecting with unknown people. Then after some point of time, it evolved into simply networking with anybody and everybody. Then by the time I would say 6 to 7 years back, I noticed this shift myself while using these social media applications. The content of your own connections on these applications only reduced. The same thing is happening even with LinkedIn. So the content shared by people of your network is much, much lesser. And all these platforms tend to have a lot of data and content of influencers, data creators, highly aimed to influence, highly aimed to create a narrative, create a perspective. A lot of these kinds of things are what you see prevalent. The amount of actual content shared by people holding accounts and networking on these platforms is less than even 10%. So, in such a scenario where social media today is used to create narratives, it has far from gone with where it started with networking, connecting virtually to people you know, today to disseminating information, disseminating misinformation, disseminating, becoming a tool of cyber warfare to a great extent. Misinformation is a tool of cyber warfare. Apart from that, going ahead, creating disruption. I'm sure everybody has heard about what happened in Nepal. Why I'm specifically talking about the social media aspect. What happened in Nepal, the so-called Gen Z revolution, etc. All of these different forms of social media toolkits. So what started as networking today is something else altogether. And I'm sure everybody here would agree that the moment you log into Instagram, how many actual posts of people you know is what you see. You just see random posts. So the entire social media is clouded with content meant to influence. Now, what way to influence it all depends upon multiple factors, geopolitical factors, the people behind the game. So, in this entire scenario of psychological warfare, social media warfare, misinformation warfare, international cyber laws gain a lot of predominance. especially with what is happening globally, what happened in Nepal, what happened in Bangladesh, what is happening in every other country today, and as a matter of fact, was attempted in India too. In such a scenario, the need and the requirement of international cyber regulation, social media regulation gains extreme paramount importance. Unfortunately, there is a serious lacuna in this also. The lacuna is because a large number of organizations will not want that regulation. A large number of big nations will not want that regulation. Let's go to the next slide. The main domains of international cyber law. I'm sure many of you have heard about these different domains. Let us discuss each of them in detail. Cross-border cybercrime cooperation. Now, most cybercrimes are cross-border. As a matter of fact, if I have to take the example of India itself, a large number of cybercrimes, which are especially nation state sponsored by other countries, are conducted with call centers in a third party country. So a third party developing country has call centers set up by some other country, and cyber criminals who sometimes are themselves victims also. So they are basically given job offers, called into a different country, their passports are taken away, they are made to sit in these call centers and commit cyber crimes. There are those aspects also where the victim and the perpetrator, it is difficult to differentiate between that. And the other aspect where these are absolutely organized crimes running cross border, wherein certain criminal entities, countries which have those kind of proxy objectives, go ahead in another third world country, set up cybercrime centers, set up call centers, entire villages are converted into hotspots for committing these crimes and targeting the particular nations and the nationals of those nations. So, a lot of times when I see in India people coming as victims of digital arrest scams, online investment scams, the biggest question that comes to my mind is, especially when most of these scams have international roots, that are these crimes against an individual? My answer would be no. These are actually crimes targeting our nation. The reason being that, the number of people who are getting targeted in our nation, there was a figure of lakhs of crores of rupees in the last year, financial year alone, which India has lost, Indian citizens have lost. If put together, that is a major chunk of Indian economy and spending power that is getting depleted. So to a great extent, this is not just a digital arrest scam against an individual who has lost a few lakhs. This is not just an investment scam against a senior citizen who has lost a crore. This is actually a large scale scam against the country where its citizens are losing a large amount of money, losing money from the economy, losing their spending power. So cross-border cybercrime cooperation becomes most important considering the number of different nations involved through which these crimes are routed. Fake centers for crimes, fake call centers set up, criminals residing in different countries, organized cartels working. So without cross-border cooperation, this is impossible. Now you will wonder, is that cooperation there today? It's actually not there. This is something that has to be achieved. Though on paper, technically, there are multiple treaties countries have signed. But when it has come to genuine cross-border cooperation, it is still far from the level it should be. The second, application of international humanitarian law to cyber operations. That becomes a bit of a tricky aspect, especially considering the reason we have something like this is, which I explained to you, the kind of cases where there are cyber criminals who are forced into committing those offenses. So where people are lured with job scams, called to a foreign country, thereafter passports taken, literally they're kept as slaves, no salaries, nothing, no way to reach back to their own country, and they're made to perform cyber crimes. They have no option but do that to survive. So to some extent, yes, there has to be certain provisions of international humanitarian law to understand what the situation of these, or what the presumption in law against these kind of criminals who are victim slash criminal both would lie, because the main kingpins are way bigger than them. These are like the pawns in the middle. The third, rules on the use of force in cyberspace. So force is a very generic term. But when I'm referring to this in cyberspace, I'm particularly referring to forceful creation of mindset, forceful creation of narratives, forceful creation of a digital fake world itself. Now, what tends to happen is what your eyes see and what your ears hear, you believe. So, in the real world, what you see, what you hear, you believe. Now, in cyberspace, especially with the use of AI, what you see may not be true. What you hear may be absolutely untrue. So, in that scenario, your brain gets tricked in a way to believe content which is fake. And this is one of the biggest tools in the hands of nation state actors, cyber criminals, everybody misusing this entire aspect where the use of force is against your own mind. Your mind, you may say, I don't get influenced by all of this, but believe me, your mind is getting influenced because by default, the mind believes, because the mind operates in a physical world where it believes what it hears, it believes what it says, it believes what it's watching, it believes the narratives being told to it, especially if it can be corroborated with visual content. And with AI in cyberspace today, all of that is manipulated. So the use of force today, somebody doesn't need to come and hold your hand and force you, you have to believe this, otherwise I'm going to do something to you. They simply need to psychologically manipulate you enough to yourself, you believing it, or probably even destroying your own life in the whole process. As we see so many cyber crimes happening against children, where children are psychologically manipulated in different forms of games, which are actually aimed at manipulating them, leading them to commit suicide, leading them to commit crimes, so many things that are happening. The next state, responsibility and attribution. Now, this is one of the major domains of international cyber law, but definitely not addressed. Large scale cyber crimes always happen through nation state actors. And unfortunately, there isn't any strong international law which attributes state responsibility till date. So if you will see, whether it may be misinformation, whether it may be cyber warfare, whether it may be hacking of critical infrastructure of countries, these are not individual hackers. They are hacking cartels backed by some or the other nation state. And unfortunately, there is a lack of regulation in this space at an international level, where state responsibility can be pinpointed, attributed, and accordingly penalization happen. The next, protection of critical infrastructure and product security. Now, this is something which is very crucial, that critical infrastructure of countries should not be touched. Unfortunately, even if it is not a situation of war, most countries will admit that on a routine basis they face attacks on their critical infrastructure. The attacks may be some from so-called hacker cartels, but in actuality they would be backed by some of the other political entity. So the principle of international law always is no form of attack happens if there is no warfare. So, okay, you don't have Air Force attack, you don't have a soldier attack, you don't have on-ground attack. But what about cyberspace? Every country will admit that cyber warfare is ongoing. So critical infrastructure protection by form of regulation is something which is very, very important. Product security. This is also something which is absolutely critical. Why I specifically mention this is because in today's day and age, manufacturing of electronic goods happens through multiple countries. Now, the software, the hardware, there can be multiple places where there are bugs, there can be multiple places with backdoors, there can be multiple other avenues in which these are compromised. And if there is no international law governing this aspect of digital products, honestly, it is an absolute danger to the entire world. The next, responsible state behavior in peacetime. Now, as I mentioned to you, any state today, any country today will mention that they are always under a threat of cyber warfare. It has never stopped. Now, even in peacetime, why does this exist then? The reason it exists is because there is no form of regulation of this. In physical warfare, there is a regulation, there are multiple treaties. In cyber warfare, to a great extent, it is unregulated by international entities. There is no common practice. And that is one of the reasons why responsible behavior of states in peacetime in cyberspace is not defined. It should be ideally. The next slide, please. The key instruments that are there as of now. The Budapest Convention on Cybercrime, it is quite old now. The criteria mentioned in it, etc., at some point were very relevant. Even today, I wouldn't say they're irrelevant, but the world has moved from cybercrime to cyber warfare. And honestly, that is what requires more addressing. The Talent Manual, the UN processes of GGE and OEWG. Now, the latest one, which we will see further in the slides, is the Digital Public Goods Alliance, which is on the privacy aspects also. There are multiple regional frameworks that are there. EU, US, China, India, all of which having extraterritorial jurisdiction, and we will see them further too. The next slide. The Budapest Convention on Cybercrime, it was the first multilateral treaty. Over 65 countries had signed it at that point of time, were part of it. It covers substantive offenses like illegal access, interception of data interference, fraud, procedural powers like search, seizure, expedited data preservation. All of these are defined in it. International cooperation, mutual legal assistance, 24/7 contact points are defined. Despite all of this being there, in a majority of cases, the actual implementation of this does not happen. The entire purpose of this convention was to harmonize offenses, facilitate evidence gathering, and foster a global cooperation in cybercrimes. The major criticism being nations like India, Russia, China opposed it due to their sovereignty and data sharing concerns and never signed the same. And for many other countries which are signatories to it, also the challenges for them continue. The regional regulatory regimes in the EU have been the NIS2 directive, enhancing cyber resilience, reporting supply chain security, supply chain referring to different digital products, mobile devices, electronic devices connected to the internet. You have the Cyber Resilience Act there, ensuring design and resilience across products. The impact of this has been a global standard which is set for the EU by vendors operating in the EU. So if you have to sell any of your products there, compliance with this helps you to comply to a global standard with respect to supply chain, product quality, design quality, to ensure that those devices are not compromised. The next slide, please. Cooperation and enforcement mechanisms. Now, under the Budapest Convention and also under the EU regime, the mutual legal assistance is MLA, which is considered as the most important aspect. It is definitely the most important aspect, but in practicality, it does not really get implemented. 24/7 contact network, rapid data preservation requests. So this is something also in case of international cybercrimes is necessary, but again, that raises questions of data sovereignty, individual nations not wanting to give access to their data. Obviously, misuse can also happen. So multiple concerns that still require addressing. Industry-assisted processes, cooperation with internet service providers and service providers. The next slide, please. National and regional framework overview. The EU, we have seen United States, China, and India being among the other major countries, those frameworks we will see. Next slide, please. In US, the major federal laws pertaining to this is the Cybersecurity Information Sharing Act, which is CISA 2015. It encourages public-private threat sharing. It protects companies from liability for good faith data sharing and is overseen by the Cybersecurity and Infrastructure Security Agency, CISA. The next slide. The Federal Information Security Management Act, FISMA of 2014, it requires federal agencies to implement NIST-based security frameworks. It mandates risk assessments and annual compliance reporting. The next slide. Computer Fraud and Abuse Act, CFAA, core anti-hacking statute of the United States. It covers unauthorized access, data theft, ransomware, and allows both civil and criminal remedies. The next slide. HIPAA. Now, most people are familiar with this, and as a matter of fact, that has gained international, you could say, standard authority in a great extent, wherein not just the United States, but almost every other country considers HIPAA as a standard for healthcare services and complies with it. Protection of patient data, mandating breach reporting and fines. Then we have the Gramm-Leach-Bliley Act, which governs financial institutions' data privacy and security in the US. The PCI DSS, governing payment data card data, payment card data, that is for credit cards, debit cards, etc. PCI DSS, though being of US origin, however, globally has been accepted as a standard in almost every country with respect to financial service providers and fintech service providers. The California Consumer Privacy Act, CCPA, the consumer rights in relation to data to know, delete, opt out, non-discrimination, all of these are regulated by that. The New York Shield Act, which expands data breach definition, mandates vendor risk management also. They have sectoral rules pertaining to defense, wherein they have the DFARS, CMMC, Energy, NERC, CIP rules. The next slide, please. The EU Cyber Framework. Now, in EU, you have the EU Agency for Cybersecurity, you have the CSIRTS CERTs response teams in each member state, the ECSO, which is a private public cybersecurity partnership, which is there, ISAC, JRC, National Agencies for Information Sharing, all of this different cyber security framework, cyber law framework is existing in the EU. The next slide, please. The EU GDPR, which almost everybody is familiar with, enforced in May 2018, was among the landmark laws globally, directives in terms of data protection, laid the foundation for a large number of countries in this space. All the principles of concept of privacy, data protection, rights of a data subject, duties of organizations processing data, collecting data, majorly have emanated from the EU GDPR. The next slide, please. The NIS Directive of 2016 applied to critical sectors like energy, healthcare, and transport. NIS 2, they also had that, 2022. Expanding obligations to supply chain and incident response. Cybersecurity Act of 2019 gives ENIS a permanent mandate and certification schemes that they can implement for different sectors. The next slide. Their main sectoral focus has been on critical infrastructure, IoT, 5G network security. The EU 5G toolbox for vendor risk management is something which one should definitely read and is also used globally as one of the standards for 5G related cybersecurity, especially for vendor risk management. The next slide. China's cyber framework that is different from EU and the United States of America. Their main key laws are the cybersecurity law, the data security law, and the personal information protection law. One of the key aspects of China and their data laws is data localization and transfer. Now, in China, critical information infrastructure operators must store data domestically. So, which means that is one of the reasons why a large number of social media platforms and data processors and organizations not having data centers within China are not allowed to operate. So, as a matter of fact, you would be aware a lot of social media operators also cannot provide their services in China. That is one of the key reasons being their local laws of data localization and cross-border transfer of data, which is regulated very strictly by CAC security assessment measures. The next slide, please. Large platforms subject to cybersecurity review before overseas listings in China. Multi-level protection scheme is there, which classifies networks from level 1 to level 5. Higher the levels, higher the stricter the security, the inspection by public security authorities. So in China, as compared to the EU and the US, there is a very strong control on data and cybercrimes for that matter of fact, from a regulatory perspective. The next slide, please. Their PIPL, which is the Personal Information Protection Act, it defines lawful basis of data processing, the rights of data subjects, and very heavy penalties imposed for violations of the rights of data subjects and lawful basis of legal processing or without consent data processing, which is up to 50 million RMB or 5% of the turnover. The next slide, please. Now we come to India's cyber framework. India is also among the global nations having a robust cyber framework, still in the process of development. India had a very sudden digital boom, and that is where the legal need for cybersecurity, data protection, and privacy was all of a sudden put together, out together post the COVID period. In India, we saw digital payments on the rise during the COVID period, BHIM, UPI, digitization, everything happened in that very short span together in India. And hence the cyber framework also came about in that entire duration. The Information Technology Act of 2000, amended in 2008, is the parent framework regulating information technologies, services, and crimes in India. The Digital Personal Data Protection Act of 2023 is what regulates consent management by organizations processing principals, data principle, processing individuals' data subjects or data principals' data. The rights of a data principal are defined there and multiple other aspects. The certain guidelines of 2022 and the most recent guidelines that have come up of 2025 regulating financial sector are very, very key frameworks, and sectoral guidelines under certain exist to regulate and lay down the frameworks of cybersecurity for different key sectors in our country. The next slide. The Information Technology Act of 2000, it provides legal recognition for digital signatures, contracts, e-governance, criminalizes hacking, unauthorized access, identity theft, fraud, malware, obscene content. Section 79, it defines intermediary liability with the concept of safe harbor, and this entire concept of intermediary liability has grown and developed through legislation over the past 10 years. That is a subject in itself. We will not delve too much into it right now. That is an entire subject in itself, intermediary liability. The next slide, please. The DPDPA 2023, which is the Digital Personal Data Protection Act of India, it regulates the processing of personal data in digital form, consent, transparency, lawful use, rights of individuals, concept of access, correction, and erasure as rights to individuals, cross-border data transfer restrictions, and compliance with the Data Protection Board of India form the key frameworks of this Act. The next slide, please. Sectoral regulations is by certain, which is under the MeitY, which is the Ministry of Information Technology in our country. Mandatory reporting of cyber incidents, log retention for 1 year, cooperation with investigations, and sector-specific, whether it may be SEBI, RBI, DOT, and NCIP, IIPC, all of these pertaining to either financial institutions or it would maybe pertaining to stockbroking institutions wherein they are regulated by SEBI. And IRDAI, which is regulating insurance sector, has also come out with multiple sectoral regulations now. Now, what are the global challenges that we see in cyber law enforcement? Now, definitely the list over there is 7 key aspects which you can read. We have already discussed this also, whether it's with evidence collection, cross borders, fragmentation of definitions, what is defined as a crime in one country may not be defined in another. Attribution difficulties, how do you attribute it, whether it's a state actor or a non-state actor? Because many times the cyber crimes committed, though may be conducted by a cartel, but it may have a state backing. The attribution of the actual offender becomes challenging. Public-private cooperation issues that occur, litigation and forensic gaps, especially in international cyber crimes, asymmetry between countries pertaining to capacity to pursue the litigation, prosecute, conduct forensics with respect to digital evidences, and privacy versus surveillance concept. Because in some countries, privacy is given paramount. Some countries, privacy along with surveillance exists. And in some countries, surveillance is there given a priority to privacy. So wherein the national policy itself is differing in multiple countries, international cooperation on those aspects becomes very challenging. The next slide, please. This is also a list of the challenges, but one of the more key important challenges that I see, which in real world, I think all of you would have seen during Operation Sindoor, and was the challenge of misinformation. So where misinformation became one of the biggest tools in a warfare, information warfare is what we call it. So the major challenge that was faced, even in the investigation of this misinformation was, the nation state actors involved, backed by others. Maybe one state actor looks at the forefront, appears to be the person, but there may be some other nation state actor backing them. Multiple layers of offenders who are there, understanding, tracking, controlling this form of information warfare, all of it is absolutely challenging. As a matter of fact, many of you would have heard about the Nayara incident also, which happened in India, which involved Microsoft. So, though there is no war actively occurring, so in the situation of war, there is a concept of companies of enemy entity. So, wherein you can basically go ahead and disrupt business, etc., of companies which are enemy entities in a situation of war. Between the United States and India, there wasn't a situation of war, which is what even the Delhi High Court and the High Court in our country, the Bombay High Court, Delhi High Courts, all of the High Courts and the supreme authorities of law also took that perspective, wherein Microsoft had gone ahead and they had gone ahead and disrupted, basically in what you would call a denial of service attack, because of whatever entities, their own nation entities, directing them to do the same, wherein Nayara, completely based on Microsoft for their data backups, for their operations, whether it may be even emails of Outlook, which most companies today are. And overnight, their entire access to it was plugged off, which led to serious losses for Nayara. They obviously approached the courts in India, and upon the courts directing Microsoft to resume and provide all data access back to them. So in a global scenario, especially even if there is no war, there are so many data crimes and cyber crimes that are taking place. In a way, this was clearly a denial of service attack that took place. So the biggest challenge that happens in this is you could say, attribution to those particular nation state actors, though everybody may understand who are the nation state actors behind this, attributing them, bringing an accountability, that is where a major challenge happens. The next slide, please. Why does privacy matter in this era? Because today cybercrime is not just a financial theft. Today, when you are using multiple applications, as a matter of fact, even your own devices today, without your authorization, have multiple other applications which are leading to, accessing your microphone, accessing your camera, collecting your data, all of your personal information, personally identifiable information, which is being collected. In many cases, AI is training on them. And unfortunately, cyber criminals who are using AI to train on your data also know how exactly to dupe you. It also has serious ramifications from a geopolitical perspective, because if individuals' data is easily accessible in such a fashion, it can be misused also in that fashion. And no nation really wants its citizen data available on a platter. So this has serious ramifications, and that's one of the reasons privacy not only matters at an individual level, but at a national level. So the next slide, please. The Digital Public Goods Alliance. So this is something I have closely worked with, because I represented India in the DPG Alliance, which is the United Nations initiative to go ahead and create a privacy framework for different organizations to follow. It primarily applies at this point of time to open source digital solutions, but any company, any organization, any digital solution can go ahead and apply for the standard too if they are complying with the different criteria. So it's a brilliant initiative. 9 countries from across the globe, each one represented by one expert. I represented India in this, and we have come together to create a very harmonious, not too expansive, not too difficult to comply, a good mix of compliance and business sense to ensure that organizations are able to comply, and in a way, nations' data risk, individuals' data risk is mitigated. The founding partners of the DPG Alliance are United Secretary General's Office, UNICEF, UNDP, governments of Norway, Sierra Leone, and major tech academic collaborators. The next slide, please. This was launched on 11 September 2025. It was publicly announced. The work on this has been going on for the past 1.5 to 2 years, where we've been working on it, but officially it was announced on 11 September. The privacy framework, the privacy annexure under this was also informed. The next. The 6 new privacy considerations under the Digital Public Goods Alliance being data minimization, collect only what is necessary, user consent mechanisms, transparency about data collection and processing, data usage transparency, clear processes for how PII is being processed and accessed, privacy by design in the data lifecycle, transparency around data retention, clear policies on how long the data is kept and when destroyed, data governance and access controls, role-based data access, isolation, and audit logs. So any organization, please go back, any organization seeking to adopt the DPGA privacy framework has to go ahead and implement these 6 considerations and accordingly make an application demonstrating the compliance of these 6 considerations in order to be eligible for the standard. The next slide, please. How does the DPGA framework protect data governance? Now, DPGA framework is meant to operate at an international level. We are not talking about a national level. So the lacuna that existed of a global privacy law or a global privacy framework not being there for organizations, this is what it addresses. It embeds privacy and security as a foundational criteria for digital public goods rather than as optional features. It encourages harm prevention and do no harm design solutions, servicing vulnerable populations like children, minors, senior citizens, populations which can be harmed by technology or by misuse of technology by cyber criminals. So the principle of designing products and solutions digitally has to be on a do no harm policy to ensure that even the vulnerable sections of society are protected and no misuse can happen. So if you see a lot of social media platforms today are being misused by some of the other entities. So the designing of a product itself has to be such way that as a principle, there are the open ends of allowing any form of harm to vulnerable sectors is completely plugged. It builds credibility and trust for DPGs, which is a key for public partner adoption and funding. So obviously, if the certification of DPG exists and the level of compliance exists in an organization, it enables people to have more public trust in them. Aligning with international regulators like GDPR, CCPA, emerging norms, and reducing legal risk for global deployment is one of the key reasons why DPGA came into the light. As a matter of fact, a lot of inputs basis the Indian DPDP Act was also provided by me to ensure that there is a harmonious synchronization of Indian laws also into the DPGA framework. The next slide, please. The implications for cybercrime prevention and global governance. With data breaches increasingly serving as an entry point for cybercrimes, whether it may be identity theft, extortion, ransomware, strengthening privacy controls is very, very important. The DPGA framework offers a model for responsible state and corporate behavior in digital infrastructure deployment, especially for national security, data sovereignty, and trust. For policymakers, it's something which is amazing because it allows them to adopt similar privacy by design principles and register open digital solutions under recognized standards like DPG, and they can also integrate privacy, cybersecurity, and governance all into one regime. The next slide.
Hello, ma'am. This is the end of the slide.
Oh, I thought there would be a thank you slide towards the end. So I will just conclude over here. So with this, I come to the end of the Digital Public Goods Alliance Privacy Annexure, which covers the entire international aspect of international law aspect currently for privacy, which is more like an umbrella framework for different nations, different organizations to be able to adopt and comply with. And yes, looking forward to all of you to go back, read up more on all these aspects and raise awareness about these aspects so that there is informed usage of the internet, informed international awareness about the cyber crimes occurring, privacy breaches occurring, what they actually imply, the impact on data sovereignty, the impact on national security for multiple countries. That's exactly how the entire scenario is in a world of cyber warfare as what we exist today. Education in cyberspace, protection of individuals, protection of vulnerable populations, regulation of technology, regulation of applications, strong, robust regulations by countries, frameworks by international bodies. These are the only way forward to, at least to some extent, ensure that digital safety exists. Thank you. Any questions, please feel free to ask.
Thank you so much, ma'am, for the session. Now we will take few questions from the audience. So drop your question in Q&A session or like just raise a hand. Shriram sir had some questions, I think. Let me allow. Yes, sir. I hope you are able to speak, sir.
Yes, hello. Can you hear me?
Yes, sir. We can hear
Yeah,
you.
yeah. Hello, Puneet. That was a wonderful session, really. Indeed, thank you very much for that. I have a question on, could you please throw some light on AI, the impact of AI across the board, and what it would do to the regulations and how the new ones are shaping up?
See, honestly, AI right now, Sriram, is highly unregulated. Probably one of the reasons why it's unregulated is why to allow it to be developed. So globally, most nations have not regulated AI. Ideally, they should. Even internationally, the regulation of AI is lacking. And to a great extent, there are major ethical and legal concerns with AI itself, though it's not as innocent as it's perpetuated to be. Uh, to a great extent, it can be a perpetrator, it can be assisting you in your work, but primarily where AI being trained on data sets without consent being obtained from individuals is the main challenge. So, as what you would have seen with the Gemini AI Sari challenge which occurred, wherein without people's knowledge, or maybe in those fine lines in terms and conditions, people are unknowingly giving away too much of their data, which leads to a lot of major tech organizations training AI on individuals' data, and thereafter, to a great extent, the level it can be misused to is massive. Fake videos can be created, fake content is already being created, fake news is already being created. There are multiple propaganda videos getting created without the people actually being a part of those videos. So, misuse of video, misuse of imagery, misuse of voice, misuse of content, all of that is a major concern. And unfortunately, in the scenario of global warfare, that is one of the biggest tools of warfare also. So, regulating it is one part of it, then regulating it, then it cannot be used as a tool of warfare. So, I think right now, globally, that balancing factor is not there.
I see. Okay, but there are these EU AI Act and also India, MeitY has published one thing on AI governance and all that, right? I mean, it is
That
in
is
works.
basically the
Yeah.
best practices and principles for AI governance. Those are not, you cannot be penalized for not complying.
You mean EU AI Act, if somebody doesn't comply to it, he will not be penalized.
See, EU AI Act is also not that stringent. It is primarily about, okay, you are supposed to take consent, you're supposed to do all of these things. But however, eventually, if you will see, that is actually not happening. So the EU GDPR itself specifically mentions that automated processing of data will require explicit consent. Even the Digital Indian Data Protection Act also mentions that. But despite that, how many organizations genuinely take your informed consent to process your data via AI? So AI is learning on your data, and legislations being sectorally there to some extent, they are, I would not say very robust to be able to control the challenges which are being posed by AI. They are very rudimentary legislations, rudimentary best practices which are being there, which are there in the form of circulars, notifications. But the best governance practices, etc. AI has gone way beyond that aspect.
And we do not know where it will still go further. Okay, with IoT and all these devices coming in, there'll be loads of data being generated, which can be, I mean, used for training and used in harmful ways.
The use of AI maybe to some extent, but yes, the misuse of AI can be even more massive than the use of AI. So my perspective definitely is, see, it's like you create a weapon and you think that, everybody will have the rationality of how to use that weapon. So it is not necessary that that may end up happening. To a great extent, the misuse of the weapon will be a lot more than the use of the weapon.
I agree.
So, does anyone have any question? Further questions? You can raise your hand.
So, yeah, I had one more question that what is the approximate rate of cyber convictions in India, cybercrime convictions?
It's very low. One of the key reasons being that the amount of data available for, you could say, pinpointing, penalizing beyond reasonable doubt, attributing the offense to an individual is not there. So majority of the cases, whatever service providers exist, like before the current regulatory regime also, the current service providers, the internet service providers are not located in the country. Prior to 2021, there was no, you could say, regulation binding them to provide data to Indian law enforcement, though there was an extraterritorial jurisdiction. Most social media applications, ISPs, application providers took the biggest excuse that, we are regulated by the law of XYZ country, you have to take a court order from them. Now, for the Indian law enforcement, there is only a certain rank officer who can actually approach the court in another country in order to obtain an order and do all of that. And the process becomes so complex that a criminal will very easily go scot-free because the investigation is so complex, it will not end up culminating properly. And in India, the principle of criminal law is 100 offenders can go free, but a single innocent person should not be penalized or should not be convicted. So this leads to a concept of beyond reasonable doubt. So the existence of foreign ISPs, Indian data not being in India, so data localization, data sovereignty, something is very, very key to ensuring actual conviction and of data offenses in India.
Yeah, unfortunately so. Yeah.
Thank you so much, sir, for your questions and your insightful answers, ma'am. I don't think there are any more questions, so we can conclude the session. Thank you so much, ma'am, for the wonderful session.
Most welcome. Most welcome.
Thank you, ma'am.